And I just want to open the microphone to you on your reading of this judge's memo tonight.
Yeah, it's fascinating. But Lawrence, what you said at the beginning is really important. We don't know who the targeted officials are, and we don't know if White House officials were complicit or completely ignorant of the scheme. What the judge is doing here is rather narrow. She's making a ruling that the attorney-client privilege doesn't protect certain documents because they were disclosed to third parties. Once you do that, you vitiate the privilege, and that means the prosecutors get to look at it. It's important, Lawrence, because it helps them build a case. And so it's going to take some time. We won't know just yet who tried to bribe whom, who conspired with whom, whether White House counsel, when learning of it, flat out rejected it and sent the conspirators on their merry way. But we do know that prosecutors and agents now have more stuff to work with. And that's the import of this decision. They get to see what would have been attorney-client privilege material.
Chuck, one more thing that I think is revealed in the judge's memo is that everyone whose name appears in this memo knows who they are because they know about the raid of the offices. They know whose email was obtained, but none of this has been made public. And so everybody in this memo, including the person in the custody of the Bureau of Prisons, everyone at this point knows who they are.
You bet they do, and that's one reason why prosecutors wanted to keep this under seal. As they said, nobody's been charged yet by the grand jury. Now, I understand what the judge is doing, and the courts have a predisposition to making as much material available to the public as they possibly can. Transparency is integral to the operation of our Article III civilian courts. But prosecutors, and I was one, Lawrence, hate it when stuff gets made public too early, because as you said, these folks know exactly who they are. And oh, by the way, if the president is handing out pardons, maybe there's a few more now on his list.
Chuck, one more technical question before we widen this, and that is the prosecutors here were basically asking the judge to overrule the filtering process that the Justice Department does in a case that involves communications with an attorney that have been intercepted. Does that indicate to you that these prosecutors were dissatisfied and sensed some kind of delay in the way the Justice Department was filtering this evidence?
No, not necessarily. Typically, a filter team works alongside but separate from the investigating team. So in other words, if my office was conducting an investigation, we did a search warrant of an attorney's office, I would have one group of assistant U.S. attorneys in my office as the investigative team and one group of assistant U.S. attorneys as the filter team. And as the filter team decided that things can be passed to the investigative team, they would do so. Sometimes when you're not sure if you can make that pass, you go to the judge and ask for permission. And Lawrence, I think that's what happened here.